What happens after arrest? What can a police do or a magistrate do? Where does the custody of the person arrested lie? Let's check out in this video. Ladies and gentlemen, boys and girls, hello, namaskar and welcome to our channel Law Charcha. We know in a cognizable case, a police can arrest without warrant. But what happens after this arrest? It is important to know that the arrested person has to be produced before the magistrate within 24 hours. Yes, this is to ensure that the police officer having power of arrest without warrant does not dictate his terms upon the person arrested. Hence, a magistrate will then decide and exercise his power of remand when the person arrested is to be produced before him. Now, what is this remand? Remand, as understood in criminal procedure, would be a process where magistrate either keeps the accused in police custody or sends him to judicial custody. Now, police custody is when the accused is in custody of police. That could be in lockup in the police station. Whereas, if judicial custody is granted, then the accused will be in jail, where he will be under control of the jailer, and the jailer would monitor his movements. And the police cannot have a direct access to the person who is in jail without permission of the magistrate. A remand is decided by the magistrate upon an application which is filed by the prosecution, who usually seeks police custody of the accused. Let me tell you here from practical experience that remand applications are just copy paste of the statement made by the first informant before the police. Few pointers stating on what grounds police custody is required that are mentioned, and often same grounds are repeated in subsequent remand applications also, showcasing the mechanical way in which the prosecution pleads for remands. In absence of any request from prosecution for police custody, which seldom happens, magistrate can direct the accused to judicial custody. A proper investigation needs a proper interrogation, and that is the whole purpose of remanding the accused to police custody. But obviously, police custody cannot be given till eternity. It has to be limited. One has to keep in mind that liberty of the person arrested, and hence CRPC caps this period of granting police custody to 15 days. After 15 days, it is mandatory that the accused be sent to judicial custody. Once an accused is in the judicial custody, the investigating agency ceases to have any power over the accused. The intent probably is to stop the police from abusing their power of arrest and custody, and probably to ensure a more effective surveillance of the arrested person or the accused. Well, can this cap of 15 days be relaxed? A similar question was posed before the Delhi High Court, where the question raised was whether a person produced before a magistrate and sent to judicial custody can later remanded to the police custody again. According to the Delhi High Court, which considered the law in detail on the subject, the nature of custody can be altered from judicial custody to a police custody and vice versa. But this can happen only during the period of those 15 days. And after 15 days, the accused can be kept in judicial custody only. Now, the Honorable Supreme Court was also dealing with a similar question, and it affirmed the position, observing that within this period of 15 days, there can be more than one order changing the nature of such custody, either from police custody to judicial custody or vice versa. And an interesting slight clarification was also touched upon by the Supreme Court. Let's see what that is. The occurrences constituting two different transactions give rise to two different cases, and the exercise of power under section 167(1) and 2 should be in consonance with the object underlying the said provisions in respect of each of those occurrences which constitute two different cases. Investigation in one specific case cannot be the same as in the other. Arrest and detention in custody in the context of section 167(1) and 2 of the code has to be truly viewed with regard to the investigation of that specific case in which the accused person has been taken into custody. So, if it is discovered that a separate offense is committed by the person who is in judicial custody, by the same person who is in judicial custody for another offense, then the police can seek his custody separately. But if commission of offense is out of the same transaction or occurrence and that is discovered, then police cannot seek a separate custody, because what will happen is that the police will keep on adding offenses for same transaction. Now, for instance, a document was forged, there was an offense registered, and then based on the same forgery of the same document, a case for cheating is also registered later on. Then a police custody of 15 days for the first offense of forgery, and then again another 15 days for the offense of cheating cannot be given to the police. Similarly, in case of kidnapping and rape of the same victim, now it may happen that offense of rape is registered at a later stage, but that does not mean police will get a separate custody of 15 plus 15 days separately, because the occurrence of offense was same. But yes, if the case is altogether different, so if kidnapping was of some different victim and rape was of some different victim, then of course separate police custody will apply. The provisions regulating remand and custody under section 57 and 167 of CRPC find backing in our constitution also in form of article 22. And my lawyer friends watching this would immediately recollect judgment of, yes, D.K. Basu versus State of West Bengal. These were the guidelines. You may please pause the video to read guidelines at ease. I must mention that this judgment is one of the landmark judgment in history of Indian judiciary. Rising numbers in custodial deaths led to the Supreme Court taking serious note of the issue, and the Supreme Court provided guidelines to protect human rights from being violated. It also observed custodial death is perhaps one of the worst crimes in a civilized society governed by rule of law. This judgment also led to some amendments in CRPC. So friends, remand is an important stage and it should not be considered lightly either by the prosecution, the defense lawyer or the judge, because from prosecution's angle, it is important to have a proper investigation conducted, for which interrogation of accused is necessary, and hence seeking police custody becomes important. From a judge's angle or magistrate's perspective also, he has to ensure that the investigating agency gets enough opportunity and time to conduct interrogation. At the same time, he also has to ensure that they do not impose themselves upon the accused. And for a defense lawyer, getting judicial custody for client is important because that gives him an opportunity to apply for bail. Yes friends, a bail application can be made by the defense lawyer as soon as the accused is remanded to judicial custody. Hence, most of the lawyers keep the bail application ready at the remand stage, and that is how it should be, because as soon as the magistrate grants judicial custody, he can entertain the bail application, and in a good case where the liberty of the accused is not required to be curtailed, he can grant bail on the same day when he remands the accused to the judicial custody. What are the parameters for granting bail? We will soon get to that. There is also something known as pre-arrest bail, an interesting insight into what has our former finance minister P. Chidambaram's case done to the arrest and bail law in our country. All this and much more in our next video. So keep watching Law Charcha, subscribe to our channel to get more updates, share knowledge in exchange of knowledge, and what you will have is more knowledge. Thank you for watching. See you soon.